probably appreciate it. There were people not right because
Oh, yeah.
I didn't know if that was
Yeah, I forgot about it.
because I well, that's kind of what I thought when I read it. Because in our business, carrier ventures.
We don't do much of it.
They finally kind of stepped it up. They're kind of snakes. I'm impressed. My dues are going. I'm happy to pay my dues. It's really doesn't
Do you work with any big clients? I don't, but I work at St. Pat's. But even with several years ago, I think the company that was going through a couple of business trying to digitize theirs, basically. Right. I've only been to one side. It's fun, and actually, cousin too. The judge should be actually. I get mad. But it was nice. You never know what they're going to do. It's so exciting.
Hi everyone. Welcome. My name is Allison Carroll. I'm the training director at the Center for Conflict Resolution. We're excited to have you all here as part of this ACR/CCR event. So I work here at CCR, and I just wanted to take a moment to thank ACR for our partnership and for us continuing to have these programs together, and to share with you all that we're glad that you could be in our space, and tell you just very quickly a little bit about what we do here, and for those of you who may not be familiar. CCR is a community mediation center that provides free mediation services throughout the Chicagoland area. We're able to do that through the use of volunteer mediators. And if anybody's interested in learning more about our services or how you could potentially become a mediator or volunteer with us as a mediator, you can certainly check out our website or pick up some of the materials that are on the blue table as you came in that were around some of the handouts for this evening's presentation. One thing came up recently that we want to make sure you all knew about. The American Bar Association's annual meeting happens to be in Chicago this summer, and they're looking for presenters to discuss topics related to dispute resolution. The audience, unlike often what the type of programs we do, the audience is going to be for practitioners, users of mediation, as opposed to mediators. So this could be a great opportunity for you to get your name out there to some users of mediation. The deadline's coming up like really soon. I think this is tomorrow at noon. But all you need to send in is a working title of the program and a brief overview of the content. So if you've got some ideas or you've done a presentation that you want to repeat, this might be a great place for you. With that, I wanted to very quickly just share a couple logistics. So if anybody needs to use the bathrooms, they are located out by the elevators. You need a key, and that's in the wicker basket up here on the blue table. For those of you who are interested in getting MCLE credit, we are an approved provider, so tonight we anticipate should be approved for general MCLE credit, and because it is related within the field of conflict resolution, the use of, or how things relate with the Civil Union Act with mediation, we do anticipate getting professionalism credit for this. So if you put your name down and your ARDC number, when you leave this evening, we'll have some certificates for you to pick up. So I know some of you put your email address. We got the forms here. Pick them up on your way out. You should be good to go. All right. With that, I want to introduce Sally and Debbie. Come on up. Talk a little about ACR. Or Sally. Hi.
Okay, thanks, Ashley. Hi, everyone. I'm Sally Drucker, and I'm president of the Association for Conflict Resolution here in Chicago. We are chapters. There is a national organization. We are an umbrella organization of all things alternative dispute resolution. And we encourage members of the community who are interested to join us. We have programs, and we do co-sponsoring programs with the Center for Conflict Resolution on our own and with other organizations over the year, generally from September through May. And our membership runs from June 30th through the following May. So if you're interested in joining and are not currently a member, you can do so tonight and get an added bonus of tonight's program as well as all the way through next May. So I encourage you to do that, and just come to me, or I'll put some forms up there for you. I also wanted to make sure that you know that if there's a special promotion. The national organization is currently now through the 30th of April offering $100 off their membership. It's normally $195. It's a really good deal. And I have forms for that. It's a special membership application form for national. And I encourage people to join national as well. They have sections for all kinds of different practitioner areas. And it's a forum where you speak to people not only in this country, but from around the world who are members. And it just broadens your horizons quite a bit. And they have very good teleconferences, webinars, and things like that that you can participate in. So again, I have those forms for you. I also wanted to let you know that our last meeting of the year is our annual meeting, and that's going to be May 10th. And the topic of our evening is going to be online dispute resolution. We don't have a lot of opportunity to learn about it, and it's growing, and so we're hopeful that it'll share a whole new area of how we work with online dispute resolution in our practices. So I encourage you to come to that. It will be here in the city as well on the evening of May 10th. That's it for Association for Conflict Resolution, and I welcome you all, and I'm really happy that you're here. Now I'm going to turn it over to Debbie Horberg, who is a CCR volunteer and also a member of ACR Chicago. Thank you.
Hi, everybody. I'm a volunteer meeting leader here at CCR, and I'm here tonight not only in that capacity and as a member of ACR, but CCR has something called the Volunteer Council, and we have about 130 volunteers who do mediations here at CCR in all different areas. We've organized the volunteers in a way so that we can contribute on a more systematic basis to support CCR, its trainings and continuing ed. And I'm one of the co-chairs of the Training and Continuing Ed Committee, and that's part of the reason that we thought it would be great to bring in Jill Metz today to talk about the Civil Union Act. And so as part of my duties, I'm going to introduce Jill. Jill Metz has spent her 33-year career litigating, advocating, and educating the public about LGBT legal issues. She was inducted into the Lesbian and Gay Hall of Fame for her outstanding work in the law and in support of and for the LGBT community. Ms. Metz serves as the president of the board of directors for the American Civil Liberties Union, ACLU, of Illinois. Her most recent speaking engagements include presenting on the financial impact of the Illinois Civil Union Act at the U.S. Federal Reserve Bank of Chicago in its series Money Matter, as well as presenting on the changing estate, adoption, and domestic relations laws since the passage of the Illinois Civil Union Act at the Governor's Office of the General Counsel, Wildman, Harold, Allen, and Dixon, LLP, Mesereau Financial, Schiller, Ducanto, and Fleck Family Law Center at DePaul University of Chicago, University College of Law, and Loyola University School of Law's Public Interest Retreat. Ms. Metz's involvement in the gay and lesbian community reaches far beyond providing specialized legal services. Ms. Metz worked tirelessly for the passage of the Illinois Civil Union Act that became effective law on June 1, 2011, and continues to work for marriage equality. Let's welcome Jill Metz.
So, as you can tell, I'm a lawyer, not a conflict resolution person in some other form. So my perspective on the civil union law comes from the fact that I've been working in the court system for 33 years without very many tools. For a little bit of bonus tonight, instead of just talking about family law, I am going to also touch on probate law and some of the things that the Civil Union Act have changed in that area, and a little bit of employment benefit area also. The Civil Union law is a new civil rights protection, as important to those people being affected by it as any other civil rights expansion that has happened in this country. It affects a very large portion of the population in the United States. It is protections really kind of unprecedented for a group that has been targeted for intolerance in the United States. The civil rights landscape, when I started practicing law in 1978, provided no protections for lesbian and gay individuals and couples in employment discrimination, in housing discrimination, credit discrimination. People lost their children, people lost their property, people lost their inheritance. When faced with an individual who was lesbian or gay and coming into the legal system, whatever the problem was, a marriage that was ending and one of the people recognized them that they were lesbian or gay, what we were doing for many, many, many years until June 1st, 2011, was patching together legal protections for people. We would find ways that the court included custody issues under the Illinois Marriage and Dissolution of Marriage Act. You could resolve custody issues for people who had two legal relationships to children, but you couldn't deal with any of their financial issues. You couldn't resolve their home. You couldn't resolve retirement benefits. You couldn't resolve separate bank accounts. You could resolve all the children's issues: custody, visitation, child support, health care, college education, but no other issues. So you would end up having to go to the Chancery Division and filing a suit for partition to get the house sold so that people wouldn't be stuck on a mortgage that they no longer were living together on a home. Or using the Chancery Division in equitable theories of constructive trust to try to create an ownership interest in a property that their name wasn't on. For instance, if someone was a veteran and got a loan for their home through the Veterans Administration, it required only veterans to be on those loans and on those titles. So the partner couldn't be on title to that home. And they didn't think that was any big deal. We're creating a family together, we're creating a life together, we're committed with each other, and so they didn't think there was anything that they should do about that. But when the relationship ended, the veteran took all the home. And the non-veteran was then looking for some solution, of which sometimes you could find solutions and sometimes you couldn't. People believed they were creating a life together, creating and owning homes together, having and raising children together, accumulating retirement money together, but the law didn't see it that way. The law left them with huge, awful surprises. I have to tell you though, in having these conversations with lesbian and gay individuals about what the Civil Union Act does, how many people are absolutely shocked that once you get married, marital assets are, no matter who earns them, the property of both people. People continue to say to me, are you telling us that no matter what I earn or where it goes, it also belongs to my civil union spouse? And that's exactly what the law does. So, you know, when you've lived for a very long time, creating your lives and all your friends doing it exactly the same way, and a lot of the people that you know doing it exactly the same way, you really didn't have any idea what heterosexual married people were getting themselves into, and then deciding whether you wanted to get into it yourself. But if you did, and generationally this will change. People my age are all still kind of like, I don't know about this. But younger people starting to have children together and beginning their lives together, they are all in this. This is like the best thing that could ever happen to create a more even playing field, which is what we hope the marriage laws do, creating protections for people and creating protections for children, which has also really just been a horrible thing that's happened in the lesbian and gay community, where people created families together but didn't do second parent adoptions, believed that they were creating the family by being a family, by taking care of the children, by going to the doctor and going to the parent-teacher conferences, and the child calling them a parent, and calling them mom, or calling them dad, or whatever the name was. The law didn't say it that way, and the law took kids away from those parents over and over and over again. We just had a case in early March in the first district that came down again that says Illinois does not recognize de facto parents. We're not doing it. We had a really old case that was really bad, and we all hated the case, and there's a little bit of hope maybe that courts would change their minds, but they have not changed their minds. We are not going to do de facto parents in Illinois. We are not going to create equitable parents here in Illinois. No way, no how. We're not doing common law. We're not doing that. So civil unions allow people to create those families in a couple of ways that I will tell you about. So because the law wasn't recognizing these relationships, people got really creative. Besides doing partnership agreements or custody agreements outside of the law, which the courts didn't recognize, but you hope that people, I mean, this is the area that you're in, you want people to be honorable, right? So if everybody understands each other, we decided we were going to have this child together, we're going to raise this child together. If our relationship ends, we'll provide support for the child, we'll allow the child to continue to have both parents. So we wrote all those agreements for years. And many, many, many of them worked, because people faced with what they knew was the moral right thing to do, which is what we try to work on, right, is followed. So those were very helpful. But downstate Illinois, they got a little bit more creative, and they started doing what are called co-guardianships downstate Illinois. They failed to know that you could actually do second parent adoptions in Illinois, and they continue to do these co-guardianships downstate. And the court has just ruled on Monday of this last week, that the biological parent in a co-guardianship can unilaterally terminate that co-guardianship, eliminating the other parent. That's been up to the appellate court once, and the appellate court sent it back down to the trial court saying you have to have a hearing. Trial court had the hearing and said, nope, she can terminate the parental rights by terminating the co-guardianship. These co-guardianships don't mean like what you think they meant, and oh well, that's the way it goes. So kids lose moms again. For many years, courts restricted visitation of women or men that realized that they were lesbian or gay and were in standard marriages. And in that divorce process, the other side became aware that they were lesbian or gay, and the appellate courts upheld very restricted visitations. Restricted visitations like you can't have any lesbian or gay people around this child. So, it's a little hard. That one went all the way up to the Illinois Supreme Court, and the Illinois Supreme Court said, well, that was a little too restricted. And so I did go back down after taking the child away for about 6 years, because it went through the court. They also said, the trial court also have said things like, you can't have any other adult females in the home when the child is there. That means no grandmothers, no aunts, no. The appellate court again said, no, that's a little too restricted. They have to, like, you have a little more reason about it. But at the trial court level, you lose. And we know trial courts are the end for most people. Most people don't have the money to take it up to the appellate court. And the kids are out of that home or in that restriction while the appellate court is figuring things out, even with the more expedited process that we're supposed to be using. So there's been lots of really harm done, not just to the parents, but to the children in same-sex relationships. In the probate area, like about 75% of the rest of the population, and lesbians and gay couples don't do wills. That's the statistic by the surveys say it's about 75% of the population don't have any wills. For same-sex couples, that's disastrous. The Probate Act says that the spouse inherits everything if there is no children, even if there is no will. And if there are children, the spouse inherits 50% and the children inherit the other 50%, irregardless of a will. Now, you can do better if you have a will. That's a lawyer talking. But at least you got the safety net. Same-sex couples in committed relationships are not spouses. They're called next best friends, and they're at the bottom of the list. So people lost everything. Spent 50 years together in a relationship, built a home together, built a life together, built up savings together. If it wasn't in a joint name, because joint assets would have been okay, but if it wasn't jointly titled, all of those assets, they were gone. Taken by family who did nothing, biological family who did nothing to accumulate them, and that person ended up in our tax dollars being taken care of by our money. Also, the survivor's estate is taxed, still currently because of federal law. So even with civil unions and even with marriage, there's huge, awful consequences to same-sex couples because of the way the law is currently, which is married people inherit 100% of the deceased spouse's estate. Doesn't know what the size of it, Bob holds millions or other people's billions went to their spouses without tax. But for same-sex couples, that's not true. And the tax is about 50% of the money above the exempt amount. The ACLU has filed a lawsuit in the state of New York. Lambda has filed lawsuits in Massachusetts. The state of New York one is the Edie Windsor case. I recommend that you look up Edie Windsor online. Edie Windsor is a terrific plaintiff. If you ever do litigation and you want to do impact litigation, you look for somebody like Edie Windsor. She and her partner were together for about 50 years. They went to California and got married. They went to Canada and got married as soon as it was available for them to be married. New York was one of those states that didn't allow people to marry, but if you got married someplace else, they recognized it. They were a couple then married in New York, and they had their whole lives together. And when Edie's partner died, the government taxed her $365,000 on the estate that wouldn't have happened if they would have recognized her marriage. So she's filed a lawsuit with the ACLU's help. And that's the case that the Justice Department has said, you know, we think this DOMA, wrongly titled Defense of Marriage Act, is unconstitutional. It's picking a suspect class, people who are targets of intolerance, and treating them differently for no governmental reason that we can figure out. And so the Justice Department has said we're not any longer defending any of these DOMA cases, but the House of Representatives has the right to defend. And so Boehner and his team have hired a lawyer, and so they're continuing to defend. But the Justice Department saying those things tells you just how far civil rights for lesbian gay individuals has come. More work needs to be done. So let's talk about the Illinois Civil Union Act, which there is a copy of that I asked people to have, so because I want everybody to actually know what it says. I think it's really important. There's a lot of misinformation out there about what this law says. And if you read it, you'll be able to tell everybody that they're wrong. Because it says it very clearly. It's not confusing. The first draft of this law, by the way, drafted by the ACLU, was like 55 pages long. Lawyers. Because it wanted to tell people in every single instance that we give rights to spouses or husbands and wives or married people, we were including people who were civil union. The belief was that that would never have passed. So it got reduced down to this lovely 2.25-page law, which says it, I think, very beautiful. So in its very section that says purposes, rules of construction, well, first it's titled the Illinois Religious Freedom Protection, Illinois Religious Freedom Protection and Civil Union Act. So to get it passed, it had to state very clearly that religious institutions would not be required to do marriages. It doesn't mean that Catholic Charities has the right to discriminate against people who they have been contacted by the state to decide whether they were proper placement for children in foster care and adoption, which is what the Catholic Charities try to say. It does say very clearly they are not required to solemnize these marriages. So, but what it says in its purposes, this act shall be liberally construed and applied to promote its underlying purposes, which are to provide adequate procedures for the certification and registration of civil unions, so provide all the nuts and bolts of how you're supposed to actually get a civil union and who's supposed to do them and all of those kinds of things, and to provide persons entering into civil unions with the obligations, responsibilities, protections, and benefits afforded or recognized by the state of Illinois to spouses. It couldn't have said it more clearly that it applies to every right, obligation, and benefit that the state of Illinois confers on married people now is conferred on civil union people. There are people as long ago as last week standing up and saying, oh, but no, it doesn't mean that because X, Y, and Z. It means exactly that. The legislative history says exactly that. That's what it means. If you go on to section 20, it says protections, obligations, and responsibilities. A party to a civil union is entitled to the same legal obligations, responsibilities, protections, and benefits as are afforded or recognized by the state of Illinois to spouses, whether they derive from statute, administrative rule, policy, common law, or any other source of civil or criminal law. I don't know how you could say it any clearer than that. In Illinois, we've done a couple of other interesting things. We broadened the tent of civil unions to include opposite-sex couples. So opposite-sex couples can use the Civil Union Act and have all the rights, benefits, and obligations of spouses in Illinois by going through a civil union. And for all the reasons that civil unions still have horrible holes in them for same-sex couples, are benefits to opposite-sex couples because the federal law doesn't apply. And as I tell you one problem, I will tell you how that's a benefit for same-sex couples, opposite-sex couples. So that's one thing the law does. The other thing it does, because the other problem that's been going on is people went off and got married in Canada. And, because Canada was before England. So they got married in Canada, or they got married in Massachusetts, because Massachusetts was very early. And then their relationship ended, and they lived in Illinois, they lived in Iowa, they lived anywhere but those states where they got, or those countries where they got married. The courts there wouldn't let them use the courts. The laws there wouldn't let them use the courts to dissolve those marriages. So they continued to be married. They continued to accumulate marital assets. They couldn't marry anybody else. They had kids. Whose kids were they? Headaches. Illinois says, in section 45, any person who enters into a civil union in Illinois consents to the jurisdiction of the courts of Illinois for the purpose of any action related to a civil union, even if one or both parties cease to reside in the state. So we have even allowed people who move away after their civil union to come back to our state and use our courts to resolve their problems. And really, there could be a whole variety of problems there. It could be a state whose probate act isn't going to recognize their marriage. They could come back and use Illinois' probate law to resolve their problems. That's not been happening yet, but that's exactly what the law says. It'll be interesting to see as we go along through this. But attempting to say, and our courts can say that. I mean, our laws can say who Illinois retains jurisdiction, and so that's basically what we've said. And the other important piece is in section, I think it's section 60. A marriage between a person of same sex, a civil union, or substantially similar legal relationship other than common law marriages, since there are no common laws in Illinois, legally entered into another jurisdiction shall be recognized in Illinois as a civil union. So if you have people who say, well, we were married in Iowa and that's not a marriage here, they're wrong. It is immediately, as of June 1st, 2011, all of those legally recognized relationship of substantially similar benefits, rights, obligations are recognized in Illinois as a civil union. It's caught a lot of people very much by surprise. It's been nice for some people. I had a couple in my office last week who were headed downtown to do their civil union after we did started their estate document process. And as we were talking, they told me they'd gone to California and got married. And I said, well, in that window, it's still, because California's really got a lot of confusion. They had domestic partners, then they had marriages, then they had Prop 8, then they didn't have marriages. So there's this little window of people in California who are legally married, and they are one of those couples in that little window. And so I said, well, congratulations, you are already civil union, you don't have to go downtown. Other people, though, quite surprised that they had to divorce, because otherwise they were still accumulating marital assets. Their children with their new relationship are really children from the other marriage, because that's what the law says. And so we did 12 gay divorces in the first week, because we're telling people, you've got to do something about this right away, because we don't know what the law is going to do. We don't know whether the law is going to say, well, really, this only starts June 1st, 2011. Or does it go back to the date of the original marriage, just not recognized as of June 1st, 2011? So we've had some cases in our office in which it clearly is going back to the beginning of the marriage, not just June 1st, 2011. And so you're going back to what the marital assets were, valuing them now, after they've been separated for 3, 5, 6 years. It's a mess. It's a mess. But for your tools, that statute is really clear. you all should know exactly who's covered, what their rights, benefits, and obligations are, how the law should apply to them, except for these odd little wiggle things, which are, we've been married longer than the act has been applied in Illinois. It is our opinion, and most other people who practice in this law, that it should be the intent of the parties. So if the people were married 10 years ago, and they divorced after June 1st, they've been living together all of those years, really you should be talking about marital assets all the way back to the date of the marriage. On the other hand, if they've been married 10 years, they've separated for 5, then all of a sudden they're legally recognized married here, civil union here, those 5 years in between really shouldn't be the consideration. It really is wrong in terms of how the law should be. So this law applies to domestic relations cases, it applies to the Probate Act, it applies to employment benefits, so employers who provide benefits to married people must provide the same benefits to non-married people, civil union. Same-sex people, civil union. Unless they are self-insured. And because ERISA says that self-insured people can devise their plans themselves, they're not insured through an insurance company, and the insurance company is really the one being regulated, they can continue to discriminate and say we're not going to provide benefits. So it has a broad reach as to how it is applied. So civil unions are really great, really glad to have them in my practice, but they're not marriage. They're not marriage for a lot of reasons, but one of the reasons they're not marriage is everybody understands marriage. It's generally understood, it has weight in the word, everybody understands what that means, and whether maybe lesbian and gay couples don't understand what it means because they've been excluded from the system, but you know, legal professionals understand what it means, hospital administrators understand what it means, benefits people understand what it means, everybody who's interacted with married people in some form understand what that word means, understand the responsibilities, the forms are all ready to go, everybody's all set to go. Civil unions, not so much. Everybody's having to redraw forms. The Department of Vital Records has had to do a whole new, well, no, they've had the form, they just had to get it to a new place. Because when you do co-parent adoptions, in Illinois, we very nicely, for a long time, have done co-parent birth certificates. So we don't take the old birth certificate, X out father and type in mother and put a woman's name in. Or like some states, Virginia won't change the form at all, but they'll put the female name in the father's spot. Or Texas won't change the birth certificate at all. Louisiana won't change the birth certificate at all. Illinois said, oh no, we'll give you a lovely new birth certificate. It will say co-parent, co-parent. And there's a particular form you use. Well, the hospitals all had to get those forms because in a civil union, a child conceived or born in the civil union is a child of both of those parents. So if all 50 states recognized our civil unions, you wouldn't need second parent adoptions anymore because the child born or conceived in that marriage is a child of that marriage, civil union, right? Not biologically related to one of the people, but that's not what the marriage law says. It doesn't say biologically related, it says conceived during the union. So that's how it applies to civil unions the same way. So when you go to the hospital to have your child, we're telling our clients, make sure that they use the co-parent form to send to Springfield so you get a co-parent birth certificate back. You still need to do a second parent adoption because of the Defense of Marriage Act, which I'll explain in just a minute. But that's really wonderful if that child was born or conceived during the civil union that just happened after June 1st. But what happens if you got married in Canada, ended that relationship, got pregnant before June 1st with a new partner? That child's not a child of that union because that union doesn't exist yet. Bang, June 1st, now you're married to this other person. And that child was conceived and born during that first marriage union. and that person needed consent to the adoption. So, yeah, there's been a lot of, like, eye-opener surprises. Come on in, sorry. Not a problem. So, lots of, you know, as we go through this process, we will eliminate these things, because we will, now that we have legally recognized relationships, everybody will get them newly, and we'll slowly work our way through the ones that are kind of a mess. But it's gonna go on for a long time. The court system, Cook and others didn't have any, when you file a lawsuit, in Cook County, you have to have a cover sheet. In the cover sheet, you have to identify what the case is. So they're for different, well, Cook didn't have any for civil union divorces, because, well, nobody's gonna get divorced, it's the second day. It's like, oh no, we're here like wanting to file them now. So that we actually, everybody was really cooperative, and we did a lot of talking ahead of time, so the forms got there in time, but it was kind of like, oh, I didn't think of that. Lots of people married who didn't want to be married anymore. Moved on, just like everybody else. DOMA, which is really a huge, awful topic. So I also ask that everybody get a copy of that statute, because I think, as you talk, this is my advocacy here as much as anything else. Everybody should tell everybody how horrible this law is. This is the most disgusting, not quite as bad. If you go and read the old statute books, and actually because we have civil unions and not marriage, Illinois statute books particularly define lesbian and gay couples as not being able to marry. It's against public policy in the state of Illinois. So that will have to change when we move to marriage. But the federal government has never defined marriage, never. It has always relied upon the states to determine what they consider to be marriage. And if you're a civil libertarian, which I'm not, but if you are, and you're arguing about, get the federal government out of our lives, how can you possibly defend this act? Because this act grabs a huge amount of power to the federal government to define what marriage is. And if they can do it to lesbian and gays, they can do it to everybody. Up until the passage of this act, which happened because Hawaii looked like it was going to have marriage for same-sex couples, happened by the Hawaiian Supreme Court in 1996. Never happened. But everybody panicked. And of course, it's the easiest thing in the world to pick on the poor little group of people who don't have enough power to really overcome this huge wave of intolerance, and this law was passed. And what it says is, it has two parts. And the first part says, no state, territory, or possession of the United States or Indian tribe shall be required to give effect to any public act. Look how broad it is. Any public act, record, or judicial proceeding of any other state, territory, possession, or tribe respecting a relationship between persons of the same sex that is treated as a marriage under the laws of such other state, territory, possession, or tribe, or a right or claim arising from such relationship. So one state in the United States does not have to recognize marriage from another state. Never before have we ever done this. That's not exactly true. Go back to interracial marriage. That's exactly what we were doing in interracial marriage. We started to have states that said, I don't know, why can't people of different races marry? No, of course. Well, change the law. And it took the U.S. Supreme Court to finally stop the last, I think it was 13 states, who still had prohibitions against interracial marriage, because it became a mess. You married somebody in one state, you moved to another state because your job took you there, and all of a sudden you weren't married. Who were your kids? It was a mess. It was a mess for employers. It was expensive. It was a mess. And that's what's happening here. The second thing it does, which is the grab, federal government grab of power, which is it determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States. The word marriage means only a legal union between one man and one woman as husband and wife, and the word spouse refers only to a person of the opposite sex who is husband or wife. Never, ever before has the federal government done something. Didn't do it during interracial marriage time period. So this law needs to go away. either through the courts or Congress standing up and having enough guts to actually say this is wrong. It will happen, but until it happens, it's a mess. I get a phone call from a woman who lives in Louisiana. She and her same-sex partner had gone to Canada and got married. And then moved back to Louisiana, why I don't know.
That's another story.
She had one biological child. The other woman had another biological child. In Illinois, those kids were legally both of their kids. That's what our law says. In Louisiana, not so much. Marriage not recognized in Louisiana. No second parent adoption in Louisiana. Not allowed. The woman who called me was a stay-at-home mom. Didn't have a job, didn't have a profession, had no money. The other woman has all the money, all the profession, and a job. She's no longer enamored with this woman and decides that she's going to move a new girlfriend in the house. But, oh, you could stay. Of course, you're going to become what? The caretaker of the kids? Who am I? She's not very happy about it and calls me and wants to know what she can do. Okay, well, if you can get to Illinois before they arrest you for kidnapping the child that's not yours, and you can wait the 6 months to get jurisdiction here, because 6 months before that, Louisiana has jurisdiction over the kids. You can't forum shop with that. The kids are both yours. But until that time period, if you leave with a child that is not biologically yours, you can be charged with kidnapping. How do you like that? That's awful. She was the primary caretaker for both of those kids. She is the parent that both of them look to for when they scrape their knees or need their homework or didn't feel good. All the things that we know primary caretakers do, primary parents do. It doesn't mean that the other woman didn't love her kids, but she had to leave behind her children. Somebody here's got this case. Maybe not here, but somebody doing mediation stuff has this case now. And it's awful, and that's because of DOMA. So that's one of the problems about one state not recognizing another state's laws. But some of the other things that DOMA does is makes domestic relations work really awful because there are no quadros allowed, so you can't take someone's pension or retirement account and divide them between two people in a civil union and not have a tax consequence. Distribution of assets generally have tax consequences, so the sale of a house and distribution of those assets, if you're not jointly titled, there'll be tax consequences of that. Health insurance coverage is taxed during the relationship to the person who's getting it as a benefit through their employer, or the employer is paying, basically increasing the salary and paying the tax. Think tank, research tank, has determined that this health insurance inequity is costing couples on an annual basis $178 million and costing employers $57 million, costing an increase in taxes of $235 million of additional taxes. I've mentioned before under the estate tax laws that the fact that you do not inherit 100% of your spouse's assets, you can only inherit up to the same exempt amount that everybody else can inherit. And Illinois has decoupled from the federal government amount, and so if your estate is above $3 million, there's an Illinois tax. If you're civil union, there's no Illinois tax, so that's a good thing. But you still have the federal tax. And there's an estimate that on an annual basis it's costing same-sex couples $3.3 million in additional taxes. The other thing you don't get is you don't get Social Security benefits. So you can't say we've been civil union, well now it's not no longer, but civil union, let's say 20 years from now. 20 years of the marriage, and so you have the right to that portion, you get Social Security benefits. Even just in the divorce you get Social Security benefits. You get death benefits if your higher earning spouse dies. So it's estimated that on an average, a couple loses about $8,000 a year because of DOMA not recognizing the civil unions. And because of DOMA, same-sex couples need to do some things that they shouldn't really have to do any longer. They shouldn't have to do second parent adoptions. I've already explained what the law says, but you can't rely on that as a parent. You have to make sure that that child is recognized, has two parents recognized by the law in all 50 states and in all countries. And so you have to do second parent adoptions because those are final judgments of law, and so they're recognized across the states, even though they're same-sex couple adoptions. Just having your civil union and your birth certificate isn't enough. So for Social Security benefits, that child would get the benefits of both adults, parents, if there's a civil union, even though the parent can't. Social Security benefits, a child does. And you have to protect in case someone is behaving badly, lesbians behaving badly, we say. Who runs off with kids and says, they're not your kids, I don't care, that birth certificate's not right. The law never recognized this relationship in Indiana. There's some really good but long-term bad for the kids because it took a long time to get there, but there's some very good law about that's been made from people who are behaving badly. You still have to have powers of attorney for help because you might be in a state that doesn't recognize your civil union. Now, everybody should have powers of attorney for health, so I'm not so like everybody should just stop doing those documents because there's really good reasons why you should have them anyway. But in a pinch, rushing to the hospital with your civil union spouse who's been injured, and you walk into the door, emergency room of the hospital, and they ask same-sex couples, I'm sorry, you can't go in there. And you say, well, I'm civil union. And the hospital says, well, no, only married people can come here. And they do still say it. You have to take your power of attorney with you. And life insurance coverage. People are still having to get life insurance because of this tax disadvantage that happens. You have to make up for that income. So people are having to expend money for those kinds of things where they should spend money to take care of their kids or whatever else they want to take care of. So that's what the law does. That's what DOMA does to the law. That's some of the horrible things that happen. So what I want to talk about last, and then I'll do a couple of hypotheticals, and then I'll open it up for questions. And if you don't have questions, I have lots of hypotheticals, because they're not really hypotheticals. A couple got married a long time ago someplace else. I think this one was Canada. They broke up before June 1st, 2011. They both hired lawyers. The lawyers did their darndest to figure out the best solution financially for them. Everybody could ask whatever they wanted to do about assets and information, and a document that was created. It was a settlement agreement. Assets were all divided up. People took titles. People paid off other things. They were all done. The document said, if you could ever divorce in Illinois, this will be your marital settlement agreement. Smart lawyers, right? It didn't work out that way. Oh my gosh, now we can actually be divorced. File the case quickly. Get into court. The lawyer on the other side says, yes, but now they're married and they have all the rights of discovery that we should have had for this dissolution if they could have had it back then. And so now we want a second crack at that one in the court. So yes. And all these real property short sales that are going on, long gone from a relationship. You end up financially upside down. You're the one in the house. You've got to get the other person to cooperate in your short sale and give all their financial information to see if the bank will give you short sales. Hard. Children, as I gave you this one before, children who are born during the first marriage, but not when you're with that person any longer, is still a child of that marriage, and the consent needs to happen. If you don't do it, and that person decides they want to create havoc, blackmail, or actually want to have a child, you'll be back in adoption court, vacating that adoption and trying to get the consents. I have lots of examples of things that have not worked out so well, and will take time to get worked out. But we've got only about another 12 minutes or so I'm going to open it up for questions and let you guys ask whatever you want to ask. Go ahead.
So can you talk a little bit about the retained jurisdiction in Illinois over divorce in situations where people decide to go to a state to get married? So they're Illinois residents, they decide to go to because they actually want marriage. That's going to be recognized here, but it's not a civil union entered into in Illinois. Is the sense that if they move out of the state later, that Illinois will retain the jurisdiction? No. Okay, that's what I thought. But
No, we're giving people, like, if you come here, I'm saying it cynically now, you come here, spend your money here, ask us to give you a civil union, we will allow you to use our courts to dissolve that civil union, but not if you go somewhere else.
okay.
I have a question about the inheritance piece. I think you kind of answered this, but I wanted just to clarify that if, I know if things are in joint name, then that's not taxed.
That's not true.
That's not true. So if you own a home jointly, and so it's 50% of that person's piece of it is still taxed.
Here's what the tax law says about estates. All assets in your name go into the pot to determine whether you have tax. So joint assets sometimes end up hurting you because it's the full value of the joint asset, and what you have to be able to show if you're audited is that the other person contributed something. So either checks that were paid for mortgage and improvements and those kinds of things. So that person can show there should be a slice of that should be included in the estate.
Oh, I see. Okay, wow.
Yeah.
That's horrible.
Bad.
Okay, thank you.
That's also for heterosexual and married people or anybody who owns joint assets. All assets in the person's name goes into the pot to determine if you rise up to that level where there's tax. Other questions? So here's one, and then we can go. Illinois has some very interesting step-parent custody and visitation laws, which you're probably familiar with if you do domestic relations work. If you've lived with a child where you are married to the parent, but it is not your child, and you do that for 5 years, you can request as a step-parent both custody and visitation. Kind of an interesting piece. So that's true of civil unions. So when does the 5 years start? Does it start June 1st? Or does it start back to the date of the marriage from somewhere else? You think date of the marriage somewhere else? I don't know. We're going to find out. We have seen twice in our country time periods where we've had this mess in the laws of relationship recognition. Interracial marriages were the first, and this is the second. And it truly is a mess. Employers are creating two totally separate sets of documents in all their benefits department. They've got to create civil union documents. Somebody was just saying that they got in the mail notification that their health insurance covers same-sex couples. I got one for a life insurance company. So, and then when the marriage comes along, they're going to have to send out those notifications all over again. And then on top of it, if we in fact, when we in fact pass marriage in Illinois, because we are, either through a lawsuit or Springfield having the courage to do it, which I think will happen. Well, what are we going to do? We're going to eliminate civil unions? Because there's heterosexual people who love civil unions because if they have a disabled child, they can't marry someone of greater wealth because that disabled child will lose their benefits. But they can be civil union and retain those benefits. That's one example. Social Security benefits, you have a high earning spouse who's died, you marry a lower earning spouse later on, and I think it's 55, I think it's 55. If you do that before 55, you lose the higher earning Social Security benefits, so you civil unions that are there. It's all in the tax code. All those people who hate the tax law, it's all in the tax code. All the benefits are in the tax code, all the hidden pitfalls are in the tax code, it's all in the tax code. We've created a maze of laws that most people, you know, don't really think about or pay any attention to until you until you bump into them. Yeah.
You know, you mentioned the tax code and how much tax revenue there is as a result of this disparity. Where would the incentive be to get rid of the disparity? Because there's so many benefits for the government just in terms of revenue, because of the tax consequences. I mean, how do you persuade, you know?
The government never takes a position that we're not going to give these benefits. Let's say the federal government has never taken a position, we're not going to give these benefits because we can't afford it. Springfield did, though. Springfield and Illinois City Council decided that they weren't going to give health insurance benefits to civil union couples because it would be too costly. Well, that's illegal. And they got phone calls and they changed their mind. But yeah, there's on other kind of levels, people have said, you know, if a company has decided that it's good business to provide health insurance coverage for same-sex couples and their kids, and to provide all those kind of benefits, the government really can afford to do it. This isn't, you know, we've been supporting you all for a long time. It's about time to cut it out. Any questions? Yeah.
Can you just talk a little bit about some of the things that are going on, especially federally, on the administrative levels in sort of trying to expand benefits for couples, for same-sex couples administratively, and some of that stuff that's going on at this point?
Well, the Obama administration, for all of what people's frustration with them on some of these levels, have done a lot of really creative things on the administrative level that they have control over. One being in the Health and Human Services area, they issued a directive that all hospitals that take federal money, which is about 99% of hospitals, have to allow same-sex partners. It doesn't even have to be civil union partners or married partners, same-sex partners, to be in the emergency room if it's medically appropriate. It's always but not just excluded. And they have the ability to sleep overnight in the same room in the hospital as married couples do, and the other things that married couples do. So that's the rule that has gone out, which makes great change. They've stopped prosecuting some immigration removals of people who are legally married in this country, but the federal government doesn't recognize them. So there's some evaluation. They haven't said exactly what they're going to do, but there's some evaluation about the fairness of that going on, and whether it will just quietly, those cases will be dismissed without making any bid or ruling about it. We don't know. And the big one was the Justice Department. The big one from my perspective was the Justice Department clearly saying that DOMA is unconstitutional, that gays and lesbians are in a suspect class, and therefore you have to use strict scrutiny to decide whether the law meets the constitutional challenge, and it does not, which is a huge step in all of the places that there's intolerance that turns itself into discrimination. So that's going to start going on.
And I think HUD as well.
Yes, I am not as familiar with it.
It just went to a final rule. So if programs that are HUD programs, which include Section 8 housing and FHA mortgages are the two big ones. The final rule says you can't discriminate based on sexual orientation, which is potentially, as you said, is the potential.
Yeah, the FHA stuff I've never really seen anybody discriminated on.
Yeah.
But in this, it could be where I'm at rather than.
In heterosexual marriages, when folks are going through a divorce, people often say you use mediation because people need to get along for their kids, for all the benefits. And before the Civil Union Act, we often talked about how mediation could be used for same-sex couples separating because they could get creative and do what works for them. Now that the Civil Union Act is passed, I'm wondering if those couples getting a divorce actually need, or as a society, we need them to use the court system to create precedent. Like, it just seems like a backwards.
I don't know about that. You have to use the court system. If you've married or a civil union, you have to divorce. You have to use the court system to do that, just as any other married couple. But I think that at least for a lot of people where you've got this gap time period, it's very helpful to try to say, look, and maybe not what the law says. It's really helpful to have another adult say, look, even though that's not what the law says necessarily, we don't know. But you have to do the right thing. I think it's really important to have that voice of morality expressed to folks.
I guess, but for those individuals, but as a society, do we need, the cases that you described, do we need precedent set to understand this law or to clarify?
Well, from my perspective, what we need is, we need to be able to show the harms of civil union. Okay. Because we need to change the marriage. We have to get rid of this system that we don't really understand, and it's a civil union because religious institutions or other people don't want to call it marriage, and so it is second class, and you have to get rid of it. So we have to see the harm, and if there's harm, if the courts actually make the harm, and an appellate court actually would rule in favor of the harm, of course it would be better for proving there's harm, but there's going to be enough of it. You know, when we first began to talk about whether civil unions were sufficient, civil unions are a wonderful tool. I can't tell you how much better it feels, though we keep getting all these odd pieces in it, but how much better it feels to know that people have at least the same flawed fallback position that everybody else has. I mean, domestic relations law is not a wonderful law to start with. It's flawed. I mean, the courts are very limited in really what they can do in really bad situations. But for a lot of people, it provides a guide. And so we have a guide now. And in the probate area, it's like night and day. Okay, you did a will and you inherit everything, or you didn't do a will and you lost everything. Probate law says, oh no, not really. You wanted to have a legally recognized relationship, you took on those responsibilities and obligations, and so we'll give you that. That is massive, and because the probate law is not like domestic relations law where anything is weighed, it's all black and white. So black and white just became really good. Whereas the domestic relations law, we just kind of got more people in the same book. But at least there's guidance in the book. Anybody else?
I have a question regarding say a couple comes from a different country like Spain, and they're a same-sex couple, and one of them, while they're here, ends up in hospital, and but they're married.
Married in Spain?
In Spain. What happens in a situation like that?
In Illinois, you're civil union. So as of June 1st, we recognize all marriages, no matter where they are from, that give substantially the same rights, benefits, and obligations as our civil union law does as a civil union. On top of which, the Health and Human Services order that went out should have your hypothetical persons, recognized as married people. So you shouldn't have any problems. And if you know someone who's having problems, you should have them call me or the ACLU or somebody. Because I know people are having problems. You know, we hear them all the time. So any of you, actually, who have encountered people who are, even if they overcame it. I tell this story about a client of mine who a long time ago, before civil unions, we did their co-parent adoption for them. And I always say, don't have them do the Social Security number before you get your changed birth certificate, because it's harder. The Social Security Administration is still struggling with this. But the hospital sometimes just does it. You sign a bunch of things because you're delirious, and there came the Social Security card. So she went down to the Social Security Administration, downtown Chicago, to get her name as a parent for this child. She's got her judgment order, she's got her birth certificate showing that she's the parent of this child, and she goes down there, and the first administration person says, oh no, we can't do that. And she stands there and she says, now wait a second, no, we can't do that. Well, I need to talk to your supervisor. And the supervisor says, well, I'm sorry, you don't have the right paperwork. And she says, well, what paperwork do I need? And they tell her something else. And she walks out the door, because it sounds somewhat reasonable, walks out the door, gets downstairs, stands outside of the federal building and says, if I can't do this for my daughter, what am I not going to be able to do for her in the future? Marches herself back upstairs, asks for another supervisor, and the next one up the level who says, oh, yeah, we should change these forms. It's still a problem. Social Security Administration has not solved this problem, and it is not an issue of federal DOMA interference. It's just the Social Security Administration just not having the forms.
How do you find out if when the Social Security number was administered? It was before or after the co-parent adoption went through?
Well,
You have to call them?
you have to find out, right, who's listed as the parent for Social Security benefits.
And so it may just be the birth parent
Right.
instead of both, if
Right.
it was done before the co-parent adoption. All right. You're having a lot.
Yeah. And it can be fixed after the, I mean, if the, one of the parents died, I mean, there's ways to fix it, but
Yeah.
it's just, it shouldn't be that hard. You should be able to walk into a Social Security Administration office with your child's birth certificate that shows that you are the parent, or your certified court order that says you're the parent of this child, and they should say, oh yes, we'll get that form out and check it and send it in, but not so much.
Okay, so they said, oh, we need to change this form. Did they?
No.
So what's it hanging?
Well, so, people push, lawyers call, and so that person gets through the process too. And then it happens again.
Wow.
It was happening in hospitals with the co-parent vital records form too. But most of the hospitals, at least in the Chicago area, now are really hip. They've got everything all worked out, and
Well, what if you need a federal document like a passport?
you mean the child needs a federal, like a passport? Well, you have birth, it's not, as long as you got a birth certificate and or the judgment of adoption, you can do birth certificate just fine. You want to know the thing that just is absolutely most aggravating to me is that if you look like a heterosexual married couple, you are a heterosexual married couple. We have a case in our office right now where a transgender female to male, passing as a man since he was 14, not married, signed the VAPS at the hospital that he was the father of the child. He couldn't possibly be the father of the child. He has no sperm. He is not the father of the child. And unfortunately for him, and I think this is wrong, but when their relationship ended, she raised this issue. He was transgendered, and he has no visitation or custody with those kids. So nobody did him any favors, but really, if you just look like it, you are. How many of you ever had to show it, any of your husbands or wives ever had to show it their employer your marriage license to get you on their health insurance? Now, more and more people are asking, because we keep raising this issue.
We were talking about as soon as you get married, you have to submit your marriage certificate to your company.
Yeah, didn't used to be.
No, it's been that way forever.
The company was hip to it right away. But lots of companies never did this.
34 years now.
But no hospital. I mean, if you go in with someone of the opposite sex of a reasonably similar age and you say, I'm her husband and I need to go in there, nobody ever stops and questions you. I mean, maybe, if she's, 18 and you're 72 or,
Or if you're African American and she's white.
Maybe, yeah, but it's very rare. I mean, my mother's never been asked to identify herself as proof it.
So, that's the struggles. Thank you very much for having me.
Thank you.